Good morning and welcome to the historic courthouse. We have 3 cases set on this morning's calendar. TOURE v. United States, 19 CF 0902, LYNNE SCHWARTZ Special Needs Trust et al. v. PNC Bank et al., 23 CV 0872, and BLACKMON v. United States, 23 CO 1044. We're happy to be hosting you all today and happy to be hosting a group of students. Welcome to the courthouse. We hope that you'll find the argument very interesting. With that, we will call the first case, TOURE v. United States, and please do correct me if I'm pronouncing that wrong. Go ahead, counsel.
Thank you, Your Honors, and may it please the court. Sean Bellinger on behalf of Mr. TOURE, and I'd like to reserve 3 minutes of my time for rebuttal. The government denied Mr. TOURE his right to confront to the confrontation by adducing scripted testimony through a surrogate witness to undercut a defense that the government had failed to investigate an important lead. In this case, there was a striking resemblance between the crime scene and a photo on the victim's website. But more than 2 weeks into the trial, the government had still not produced any evidence that it had ever investigated this lead. The prosecutor was so concerned about this gap in the government's case that at the close of his case in chief, he scripted Sergeant Batten to provide hearsay testimony that the victim's website had been investigated, but did not provide anything useful. Sergeant Batten had no personal knowledge of that investigation into the victim's website, and the prosecutor who had issued the grand jury subpoena and evaluated the responsive data was the only person with firsthand knowledge.
So firsthand knowledge of what? The question was any investigation of these IP addresses conducted? And the defense theory of the case was no, there was a rush to judgment and these very important leads were left unexplored. And isn't that exactly what the trial court's instruction, curative instruction, accomplished for the defense?
No, Your Honor, we think the instruction left the defense in the worst possible position. The only permissible remedy under the Constitution when the prosecutor decided to interject his findings and his conclusions that the lead was not a useful lead was to put the prosecutor on the stand to make those statements in front of the jury. The defense, under the court's instruction, the defense was allowed to cross-examine Sergeant Batten, but Sergeant Batten had no personal knowledge of that information. He could only parrot back what the prosecutor had told him the night before.
Well, counsel, it's fair to say there's a significant amount of evidence in this case that implicates Mr. TOURE. How do we assume, or how do we strip out and say that this evidence, even if we assumed a constitutional violation, was enough to get past the even heightened harmlessness requirement of a constitutional violation?
Yes, Your Honor. So as this court recognized in Garner, the prosecutor's real-time evaluation of his own case is the best gauge for the importance of the issue of the website investigation. And the facts surrounding the misconduct in this case demonstrate how important the investigation was. The prosecutor interjected the investigation and his findings of that investigation after he presented all the other evidence in this case and after he saw the jury's reaction to all the other evidence. But yet he remained so concerned about this gap in his case that he was willing to engage in misconduct to close that gap.
But
So the purpose of confronting the prosecutor was not to establish that there was no investigation as much as it was to show that the prosecutor thought that was a real weakness in the case, to expose his own views on the matter?
Well, as Your Honor said in her concurrence in Shelton, that could have been an inference that the defense could have probed. But the main inference, the defense wanted to probe was the adequacy of that investigation to the victim's website and why it didn't yield a useful lead.
But
Why?
isn't that worse for you? Wouldn't that have been worse for the defendant? I mean, the implication from the trial court's instruction was no investigation was conducted. I mean, that seems like if I'm defense counsel, that's the best outcome for me because that shows that leads were unexplored and that creates reasonable doubt. If the prosecutor gets on the stand and says, here are the 4 reasons I didn't investigate this, or as I started to investigate them, they didn't lead anywhere, that seems to be undercutting the very, defense theory of the case.
Well, Your Honor, under harmless error analysis, you presume the impact of the cross-examination would have been favorable to the offense. So that's the starting point. But on top of that, the court's instruction was not that the government didn't investigate the website. The court didn't strike Sergeant Bann's testimony. I'm paraphrasing here, she stated that the jury can give it whatever weight they wanted to give it. And then she allowed the government to introduce the grand jury subpoena, which corroborated the fact that the investigation into the victim's website did occur and it wasn't a useful lead.
But I mean, it was Mr. Toure himself who declined an offer to strike the testimony, right? I mean, that was offered.
Your Honor, once the prosecutor decided to interject his hearsay statements into the case, Mr. Toure, it was his choice in remedy. And under the confrontation clause, he was entitled to cross-examine the prosecutor whose statements were interjected into trial. Again, this was the prosecutor who made the strategic decision to interject these statements into the case.
How do we know that it's really the 100% that it's the prosecutor? I get the idea that the prosecutor was who chose to interject it, but they're the source. They ran the IP searches themselves.
Your Honor, Sergeant Batten testified that he was told the night before his testimony that the prosecutor had told him about the grand jury investigation. The prosecutor ran the grand jury investigation. The prosecutor had told him that the lead wasn't ultimately useful. And those facts, I think you could also infer from the record that the prosecutor didn't call another witness. He simply scripted Sergeant Batten. So I think that's also an inference from the record that Sergeant Batten was the person who, well, he's certainly the person who made the testimonial statements to Sergeant Batten, which made their way into the trial.
Was there any discussion of whether the prosecutor could even testify as to the investigation under 6E? Or, I mean, I guess perhaps it would have fallen under a court order exception to 6E?
There was no discussion of that on the record, Your Honor. But under the confrontation clause, that's the controlling law. And once he interjected that issue, anything short of putting him on the stand in front of the jury violated Mr. Toure's rights.
So in your view, it's a very bright line rule.
Yes, Your Honor. The confrontation clause, once testimonial statements make their way into the trial, the Supreme Court's clear, this court is clear that that's one of the foundational principle of our adversarial criminal law system, that the defendant has the right to confront the evidence against him.
I mean, you would agree, though, that it's still subject to Chapman harmless error review, right? So it's not structural error. It's not per se error. It's not per se reversible error.
It's not per se reversible error. It's harmless error. And it's the government's burden to show that the error was harmless beyond a reasonable doubt. And that's a difficult burden for the government here, because we don't know what Mr. Nessler would have said had he taken the stand.
But if that's the scenario, it also presumes there's some room for the trial judge to try to exercise some discretion and come up with a remedy like they did here to try to eliminate any potential harm, as opposed to automatically calling up the prosecutor and turning an attorney into a fact witness and essentially blowing up the trial.
Well,
Would you agree?
respectfully, I don't, Your Honor. The constitutional right to confrontation gave the judge no discretion when the prosecutor decided to interject this issue into the case. There was some talk of a compelling and legitimate interest. We think that test would be easily met here to make the prosecutor a witness. The prosecutor made the strategic decision himself to interject his investigative work into the trial. He couldn't hide behind a surrogate witness. The law is clear that he needed to testify in front of the jury if he wanted to interject that the victim's website into the trial. In any logistical concerns associated with calling the prosecutor as a witness are vastly outweighed by Mr. Torrey's interest in his Sixth Amendment rights.
Can I?
I want to go back to your answer to Judge Shanker about harmless error, maybe it was Judge Shanker, sorry. You said we don't know what Mr. Nessler would have said had he been subjected to cross-examination, but is that it? Before you said we assume that it would have been favorable to the defense. So what would it have been? What would have been the best that the defense could have expected Mr. Nessler to say?
Yes, Your Honor. The best case scenario, again, we don't know. The defense could have found out that once the prosecutor took the stand, the investigation was inadequate, and there were alternative suspects that were not looked into. Again,
That
this-
it was inadequate, but that there were, but that it nonetheless identified alternative suspects?
that either or, again, we don't know. We don't know what would have happened had he taken the stand under oath, subject to cross-examination. I think either of those inferences in the prosecutor's own real-time evaluation were the investigation into the victim's website was so important that in his real-time evaluation, he was willing to engage in misconduct to plug that gap. So I think that's another clue to the harmless error analysis here.
But that's, okay, that's what I was trying to kind of parse what I will call, this is not fair to call one the substance. In other words, what was done,
Right,
and the other one, what does that say about the prosecutor's own view
right,
of the strength
Right.
or weaknesses
right.
of the government's case? On the former, doesn't the stipulation that was reached that said the government didn't investigate really beyond, I guess, that subpoena, right?
Well,
Doesn't that take care of what the defense was trying to establish? They didn't investigate.
no, Your Honor, we think that the court's instructions were give whatever weight you would like to Sergeant Batten, to the jury, which in Sergeant Batten testified that he was told that the prosecutor, who's again has all the credibility of the government behind him, looked into these IP addresses, and then the court allowed the government to corroborate that by saying that they subpoenaed them on the grand jury, but didn't take any further steps.
Right.
So we don't know why they didn't take any further steps. And the inference the jury could have made was they followed up on this as far as they could.
No, but the stipulation says the opposite. Did not take any further steps, right? Is that not what it was?
We don't, again, Your Honor, we don't know why they didn't take any further steps. Is it because they were infeasible? And the defense counsel at trial in the March 14th hearing spells this out well, the inference that they think the jury could take away from this and why they didn't get their point across about the inadequate investigation. All the jury knows is that these were looked into and they weren't a useful lead. These being the website, the IP addresses that visited the website.
But so then, I mean, you seem to be theorizing that the prosecutor would have gotten on the stand and said, we looked into this and they led to this other person, but I didn't want to pursue that because it would have tanked my case. I mean, that's really the best thing that could have happened for you. I mean, right? That's the only thing that could have happened for you. That's better than, we just didn't investigate this. Don't know why, we just didn't. I mean, the only thing that's better for the defense is we didn't investigate this because I didn't want to, because it would have tanked the theory that we've been exploring for 2 years, that it's Mr. Toure.
Your Honor, that's under this court's harmless error analysis. Again, you presume the favorable cross-examination were to occur.
Yeah, I just don't know if the law requires us to presume something so far-fetched, really. I mean, I don't know. I'd have to look, I have to look into the law more clearly on this, but that just seems very unlikely to me when your whole theory of the case was an inadequate investigation was conducted. Right? It seems unlikely to me that then, and with Judge Ruiz's question, the stipulation was no investigation was conducted as to this aspect. And then to expect that the prosecutor would get up there and say, yeah, actually an investigation was conducted and it led to another person, but we didn't want to pursue that. It just requires us to engage in a lot of, hypothesizing to reverse a conviction. Sorry, but let me ask you another question. There's two prongs of this case and two issues in this case. You've only really discussed one of them. On the Brady piece, if we were to reach harmless or prejudice on the Brady prong, and for purposes of deciding that question, we assumed that all of the DFS related evidence, we're not considering it, right? Then now move to issue number 2, the issue we've just discussed. In evaluating Chapman harmlessness on the confrontation question, could we then consider the DNA evidence that we did not consider on issue number 1, the Brady issue? Does that question make any sense to you?
Your Honor, are you sort of talking about assuming compounding errors or?
I guess that might be part of your answer.
So under Sims, this court, for the harmless error analysis, it does look at the cumulative impact of all the errors in this case.
I mean, I guess for evaluating Chapman harmlessness on the confrontation question, it seems to me that we have to consider all the evidence that did come in, even if on issue 1, we're assuming that evidence doesn't come in to evaluate Brady prejudice. And so correct me, or tell me if I'm wrong, that we could still consider the DFS related DNA evidence under Chapman harmlessness on issue number 2.
Your Honor, you can look at each violation independently and also cumulatively. If you found that they were both violations, you would look at them cumulatively. If you found one was a violation, one wasn't, you would look at them individually. We think either way you look at it, sufficient for the grant of a new trial here. I just want to touch, sorry, I saw my time expire. Could I brief leave to?
But can
You
you-
may.
Yeah, but okay, cumulative. And then, so now we're into harmlessness. What do you look at? Can you consider the DFS evidence, DNA evidence?
Yes, you could.
You could.
You could, excuse me, you could consider the
In weighing the weight of the government's case, do we take into account that there was those DNA, that DNA analysis that identified Mr. Toure as contributor to the samples?
So, Your Honor, the undisclosed impeachment evidence, we think would have weakened the DNA evidence.
Right.
Setting that aside, setting that issue aside and just looking at, focusing on the confrontation issue at this point. We think that the court could look at the evidence, but it's like, the court stated in Gardner, you would look at it through the view of the prosecutor's real-time evaluation, who felt the issue about the government's investigation into the victim's website was so important that he was willing to sneak the evidence in through a surrogate witness. Again, as far as the far-fetched aspect of the damaging impact of that cross-examination, the reason why the law presumes the favorable cross-examination is because the truth-seeking function is supposed to be done through the confrontation clause. And so if we don't know what would have happened, it has to be presumed that it would have been favorable for us to give any teeth to the confrontation clause. If not, you know, it affirms the sort of trial by affidavit, trial through surrogates. So that's the reason why we need to presume.
So just to make sure I have your point clear, you're saying in focusing on this particular evidence, because of the confrontation clause issue, we have one presumption that it needs to be favorable to the defense. I have no issue there. So that gives one boost to the value of it.
Mhm.
And then you're saying, based on the case law, we need to look at it from the perspective of the prosecutor, which, assuming we take your argument, at face value for that, for the import of it, makes it supremely more important than anything else. And that gives it another boost all the way up to here. And then we weigh all the other evidence, the video, the smart trip card, the credit cards, possession, everything else kind of against this, with this dually kind of stat boosted inflated value.
Right, and the added point is it's the government's burden to prove that it's harmless beyond a reasonable doubt.
Mm.
So that's the correct way to look at it, Your Honor.
And do we add to Judge Howard's stack of evidence, the DNA analysis, the results of the DNA analysis? Even if we were to think that there was, I'll say a Brady violation,
Right,
including
right.
materiality, yes.
I think you would have to, under the cumulative analysis, you would have to consider the DNA analysis discounted by the undisclosed impeachment evidence to that DNA.
Discounted by the, okay.
Yes, exactly, Your Honor. I think that would be the calculus.
Which again means that, do we kind of assume that the impeachment would have had its quote intended effect of making the jury say, I'm not going to believe any of this DNA analysis?
Your Honor, the Brady calculation is a little different. You
Right.
do focus on the impeachment value and not the sufficiency of the other evidence with the Brady inquiry, but so
Right, but we'd say, well, the impeachment would have had kind of the hopeful effect. And what is that? Is that not what the way we're supposed to look at that?
Yes, Your Honor. We would agree with that way to look at the cumulative impact of the errors in this case.
And last question from me, in terms of, you've reiterated the point about how we should look at how the prosecutor valued the particular point of evidence in sponsoring the testimony that you have the confrontation clause issue with. You've reiterated the answer a few times and really stressed the value of it in a way that I think possibly makes it look like you may think it's an objective analysis, but would you agree that that's a subjective analysis based on our review of the record? It's how we think the prosecutor judged that, as opposed to a presumption that this was so key, though there is evidence that would point towards it being important if someone felt the need to sponsor false testimony.
I think it's a factor that weighs in our favor Absolutely. I don't. I think you could look at it subjectively or objectively. The more important point is that it's a factor that should be accounted for in the harmless error analysis.
There's no further questions. Thank you, Mr. Bellinger.
Thank you.
We are still reserving your time for
Thank
rebuttal. Mr. Lenners?
Thank you, Your Honor. Good morning, and may it please the court, Dan Lenners for the United States. The evidence of HADJI TOURE's guilt of the horrific rape and murder of Karina Meal was overwhelming. Mr. TOURE's DNA was found in semen found inside Karina's vagina. Mr. TOURE's DNA was also found in a semen stain on a pair of Ms. Meal's leggings that he used to bind her ankles. His DNA was also found on swabs taken from multiple different of her intimate areas.
So, but Mr. Lenners, let's just assume that, I mean, you have conceded a Brady violation, at least for purposes of appeal. And so the question comes down to prejudice / materiality. And your friend on the other side's argument is essentially, we have to assume that the jury would have just thrown up its arms and said, you can't trust anything DFS did, anything. I mean, that's what they're asking us to do. I'm not saying that that's what would have happened, but that's what they're asking us to do. In your brief, you said, okay, we can do that at least as to everything other than the leggings, and there's still overwhelming evidence. But you put the leggings back in the plus column. And I'm asking you whether your argument remains the same if we take the leggings out, because under your friend's argument, let's just say the jury said, we don't trust anything DFS did, including the handling of the leggings, which they did at some point, right? So is your argument that basically all of the video evidence, all of the evidence that he used, the credit cards, the knife, all of that is overwhelming?
Yes, and there's no chance that the jury would have discredited the DNA found on the leggings, and I can explain why. But to answer Your Honor's question directly, yes. Mr. TOURE was captured on video approaching Karina's apartment immediately before she was murdered. He was then captured on video hours after she was raped and murdered using her credit and debit cards for which he had to know the PIN. The only possible way he could have known the PIN was from her. He showed guilty knowledge when he abandoned her car 2 days after raping and murdering her. He continued to use her credit and debit cards and is the only person ever seen using them, never got the PIN wrong, and then later used the cash to buy his own car, which he didn't have earlier. So there's no world in which this wasn't a consent case. This wasn't a self-defense case. The only possible defense was misidentification. And there is no world, and even without DNA evidence, that a jury would have had a reasonable doubt that anyone other than TOURE raped and murdered Karina Meal. But there's good reason to believe that even if the jury had doubts about DFS's own DNA analysis, they wouldn't have discounted the DNA found on the leggings. And here's why. There's 3 reasons. First, the 2 people from DFS involved in handling the leggings had no cue cars of their own. So there was no suggestion in the many years of cue cars that were turned over to the defense that they had even made a mistake worthy of a cue car.
I'm sorry, may I interrupt you there? I thought, and I'm not remembering the name, I thought that there was a disclosed cue car with respect to one of the people who handled the leggings, but we don't know what that said, what that cue car was. Is that incorrect?
I don't believe that's right, Your Honor.
Okay.
The people were Karina Bleach and Aaron Daniels. And there's a list in our supplemental record of all the cue cars that were turned over. I believe the trial court found, and we said in our brief, that neither of them was the subject of a cue car, and the defense has not disputed that. Second, their handling of that evidence was minimal. Karina's body was recovered from the crime scene by the office of the chief medical examiner. It was taken directly to the medical examiner's office, where her clothing was removed by a medical examiner. All that Ms. Bleach and Ms. Daniels did was take that evidence that had been collected, removed from her body by the medical examiner, put it in a bag, seal the bag and barcode it. And then that bag was sent to Signature Science. And so there's nothing they did that would have led to some sort of contamination of evidence, particularly given the timing. This was all done on March 22nd. Ms. Meal was murdered on March 20th. Her body was found on the 21st. All of this evidence recovery was done on the 22nd. TOURE was not identified as a suspect or arrested until March 27th. So there's no sloppiness through which his semen could have gotten on her leggings because they didn't even know who he was at the time. So the only possible inference is malfeasance, that after he was identified, somehow they obtained his semen, unsealed the bags, put it on the leggings, resealed them, faked the date, and sent it to Signature Science. That's preposterous. So even if you assume that, which we don't think is the correct assumption, that the jury would have discounted DFS's DNA analysis based on the undisclosed cue cards, there's no chance that they would have discounted the Signature Science DNA analysis. And again, this was a stranger rape and murder. TOURE's DNA in semen on the rape and murder victim's leggings conclusively established his guilt of that case. That was proof beyond a reasonable doubt without any other evidence. And Judge Schenker, as I mentioned earlier, there was ample other evidence of his identification. On the Confrontation Clause issue that my opposing counsel has highlighted, the defense waived any Confrontation Clause challenge when they declined the judge's invitation to strike Detective Batten's testimony and to instruct the jury that MPD had done no further investigation. The judge made crystal clear on multiple occasions the defense had that option. The defense declined that option. They wanted to keep his testimony in the record so that they could cross-examine him about it and then argued prosecutorial misconduct, which is exactly what they got here. That's precisely what they argued in closing. They were far better off in their eyes, and these were experienced PDS defense attorneys. They made this strategic decision. They wanted not only to argue this failure to investigate, which they were able to argue based on the judge's corrective instructions, but also prosecutorial malfeasance.
But is it your position that striking testimony is always a sufficient cure to a Confrontation Clause violation?
Yes, the violation is allowing in unrebutted hearsay, and if you strike it, it's no longer in. But the judge was willing to go further. She offered them, I'll strike this, and I'll also affirmatively instruct the jury that MPD did no investigation into the similarity between the photo on her website and the IP addresses. And the defense declined that. They wanted more. They wanted to be able to argue that Mr. Nessler had committed misconduct, and they did argue that. And so so this is not viewed under sort of confrontation harmless beyond a reasonable doubt, because the defense waived that when they kept the testimony in. It's evaluated under the abuse of discretion test that applies when they want to call the prosecutor as a witness, which, as the court noted, is a highly disfavored remedy because it would blow up the trial. And again, they also ask us to speculate that Mr. Nessler would have said, oh yeah, I thought our investigation was weak. I've never discussed this with Jeff. There's no defense counsel that would ever ask that question, because the way he would answer is absolutely not. This is the strongest case I've ever tried. TOURE's DNA was in her vagina. His DNA was on her leggings. It was all over her intimate areas. He is on all of those videos. I do not think my case is weak in the slightest. This is an overwhelmingly powerful case. So defense wouldn't have asked that question. And the questions they do speculate that they wanted to ask him were not ultimately relevant to TOURE's guilt or innocence. And we also know what Mr. Nessler would have said because it's in the record. He emailed the court before he knew anything about what Batten would testify and said the grand jury was investigating who accessed Ms. Meal's website during the time of the murder. And one of those IP addresses linked to the city of New York, and the other four were mobile IP addresses that don't belong to a single person or device, and so you can't really follow up on them.
So I think you've insinuated the answer to this already, but going a different direction and assuming, for the sake of argument right now, that we did find some sort of constitutional violation, and we're supposed to look at how crucial this is, as your opposing counsel asserts, to the government's case. We certainly have their view. And like I said, I think you've already implied by talking about all the other things that were crucial to the case, and you haven't once mentioned IP addresses, how crucial you think it is to the prosecution's case. But how crucial does the U.S. Attorney's Office think that this particular evidence was, if it actually raised confrontation issues?
It was a minimal part of the U.S. Attorney's Office's case. Sergeant Batten was testifying as a summary witness who was tying up a bunch of different loose ends. He covered a lot of different topics.
66th or 65th witness, right?
Yes, Your Honor. And he wasn't just testifying as to things he had personally done. He was testifying as to things that other detectives on his team of detectives had done. And they were just going through piece by piece, tying up loose ends. This was a loose end that was tied up. It was 3 questions, I believe, by Mr. Nessler, maybe 4. It was a very, very small piece of the puzzle. And so
But Mr. Nessel knew that what the sergeant was saying was untrue.
I don't think that's right, Your Honor. Mr. Nessler misspoke in asking, did detectives follow up? He obviously that was inaccurate. He should have asked, did law enforcement or did the grand jury follow up? But it's true that there was a follow-up, that the IP addresses had been subpoenaed, that someone in the U.S. Attorney's Office had done an analysis to figure out which IP addresses matched up to the correct time frame, and then attempt to match those IP addresses.
What exactly did the sergeant respond? I mean, what were the words that the sergeant used? You're saying that maybe the question was posed, you say inartfully, but what was the sergeant's response?
He said yes, but that was corrected later when he was cross-examined and admitted, no, we didn't. Detectives did not. I'm not aware of anyone in MPD who followed up on these IP addresses. I don't even know what mobile IP addresses meant. So any false testimony was corrected during the cross-examination. And the defense never argued that below. They never argued that the jury was left with some false impression. And in fact, the judge repeatedly said, Sergeant Batten's very candid testimony cleared up any misunderstanding here. Everyone knows exactly that MPD did nothing itself to follow up on this link. And so for that reason, we think that the judge didn't abuse her discretion in declining the defense's request to call Mr. Nessler as a witness. But even if the court thinks there's some error here, it's plainly harmless given the weight of the evidence of Troy's guilt.
Thank you, Mr. Lenners. Mr. Bellinger?
Thank you, Your Honor. Just a couple of points, starting with the confrontation clause. So the prosecution cannot now, on appeal, disavow their real-time evaluation of their own case. At the time, the prosecutor, who's an experienced prosecutor, after presenting all his evidence and seeing the jury's reaction to all that evidence, thought that the gap in his case related to the website investigation was important, and that the other evidence was not so overwhelming that he didn't need to address this. He made the strategic decision to interject that issue into the trial.
But I mean, what legal basis do we have to say that a prosecutor's, if we assume prosecutorial misconduct here, that a prosecutor's motivation for committing misconduct is relevant evidence for the jury in determining guilt or innocence?
So Judge Reese's concurrence in Shelton is one, but the jury has wide discretion to evaluate the evidence. Again, here,
I mean, the question is it evidence? I mean, it's, yes, they have wide discretion to consider the evidence, but this seems like almost like a nullification argument based on motivation for committing misconduct. I'm not sure that's evidence related to the facts of the crime.
the jury could consider that appraisal of the other evidence as it not being overwhelming. And that's not even, again, that's not the only consideration under the harmless error analysis. Here, again, we presume substantively that the cross-examination would have been fruitful, and the investigation into the website was inadequate.
Okay, so I mean, the false testimony that was elicited was that an investigation was conducted, right? And so if that had been stricken, then how is that not a complete cure to that elicitation of false testimony?
Well, it's not just that an investigation was conducted, it's that an investigation was conducted and it didn't yield any useful information to finding, say, alternative suspects. The defense wants to show that this was a useful clue. They want to cross-examine the prosecutor to develop fodder to say, look at how closely this photo on the website resembles the crime scene. And was your investigation adequate? How do you know IP addresses weren't useful? What's your training, et cetera? All of that would have, again, we don't know what.
But those questions go, and this is where I'm trying, and that's what Judge Shanker was also, what did you actually do in terms of an investigation, right? Did you really investigate, or did you just zero in on Mr. Toure and, the narrow focus and rush to judgment, all that? Or is it the prosecutor thought there was a weakness in the case and we want to expose what the prosecutor thought? Because we think that from that, the jury can think, well, if the prosecutor was concerned, maybe we should be concerned.
It's both, Your Honor. You could consider them.
But they're different things. And
Exactly.
so Judge Shanker asked, well, but as to this second part,
Right.
is that evidence? Is that something that the jury can appropriately take into account? And the argument there, I mean, I've said this before, is that we do allow inferences from certain things like withholding evidence, or, people hide things. Why? Because they think that if they were disclosed, they would be detrimental to their case or to their position, and that this is no different from that. Inserting evidence in is not that different from leaving it out, right? Taking it
Exactly,
out.
Your Honor.
It's manipulating the evidence that the jury sees, because you think that unless you do that, you will be hurt. Your case will be hurt. As I understand it, that's the argument.
Exactly, Your Honor. That's exactly it.
But was that presented to the trial court as, judge, this is what we're trying to do?
Your Honor, the defense at trial states they want to cross-examine Sergeant Baden. I think it's the March 13th and March 14th, 2019 transcripts. There's extensive litigation about why they want to cross-examine the prosecutor. And that is, I believe that is one of the reasons. Yes, it was to evaluate the adequacy of the investigation and to also see, explore topics further. They didn't, because the court shut off that remedy very quickly. There was not an extensive discussion beyond exploring the adequacy of the investigation and why the website was looked into in the first place.
Let us assume that we were to decide, this is a hypothetical, that this case needed to be reversed and remanded for a new trial based on the Brady. Okay, hypothetical. New trial. Could you then, or any defense counsel then representing Mr. Toure at this new trial, seek to introduce into evidence what happened at this former trial in terms of what the prosecutor, you say, tried to do, which was insert this evidence into the testimony of Sergeant Batten for the purpose of showing how the government had previously viewed the strength of the government's case.
I believe they could, Your Honor, but to be clear, the confrontation remedy is triggered by the prosecutor's decision to interject that into that trial, into the trial that is at issue in this appeal. So there wouldn't, to bring up this issue on the next trial, it wouldn't necessarily be a confrontation issue.
No, it
Unless-
wouldn't be. I would,
right.
that's why I
But they
say,
could bring, they
I would say
could.
as a standalone thing. You think
Right.
that that would be an admissible line of questioning? I don't know how exactly you would get it in, but if that wanted to make that point. Would
Yes,
that
Your
be
Honor.
admissible evidence?
Yes, Your Honor.
And for that, you cite, what's your authority for that? And please don't cite me.
Your Honor, I don't have authority with me
Okay,
on me right now. And to correct one thing on the record for the Brady issue, counsel stated that the DFS intermediaries between Signature Science and the crime scene, neither of them had cue cards. I think counsel misspoke because Aaron Daniels did have a cue car, and in their disclosure, her last name was Luber, and so I think was the confusion there. The last name changed to Daniels, and so she did have one cue car.
But that was,
that one was disclosed.
Disclosed.
pre-trial,
That one was disclosed
And
pre-trial,
it was not used during trial.
and it was not used during trial because, again, the majority of the cue cars and the most serious cue cars were not disclosed until after trial. That's
But,
correct.
and we don't know on the record, I take it, what that cue card said about Ms. Daniels.
No, Your Honor, I could provide that to the court
No,
if,
I mean, it's not in the record, right? 'Cause
it's not on the
I
record,
wasn't able to find it.
right?
But the point is, though, it was not used in your examination of, or your argument in the trial court.
Actually, Your Honor, our motion for new trial does attach
Okay.
the cue car
For Ms. Daniels.
disclosures beforehand, but I could make that available to the court in a separate filing if it would be easier for their reference.
Okay, thank you.
Thank you, Your Honor.
All right. If there's no further questions, Mr. Bellinger, Mr. Gordon, thank you very much for taking this case on. And to your firm, Mr. Lenners and Ms. Cole, thank you for your argument. This case is submitted. Right, having given folks in the courtroom a chance to come out, we are going to move next. Invite the parties up for the LYNNE Schwartz Special Needs Trust v. PNC Bank case. Morning, Mr. Schwartz. Would you like to reserve any time?
I preserved 5 minutes. Thank you. Morning, Your Honors. My name is Frederick Schwartz, and I represent a number of entities and individuals, all of which seem to share my last name, but this is independent representation. May it please the court, although I doubt whether it will. We are now examining what I think is a very bizarre case, a case where representations were made by a bank that traveler's check, a cashier's check was not authorized. And then 4 years later, after we proceeded with what I call a very extensive litigation, and as you can tell from the record, it was extensive. They suddenly discovered, oh no, we cheated that check, and therefore we're not responsible for anything. In the process of the litigation, there were a number of errors we would maintain by the court, Superior Court, but as I see the outcome from this court, the simplest route to follow will avoid most of them, even though most of them were discretionary. It seems to me that principal error was not permitting the amendment to the complaint. When the amendment was not allowed, not only did the complaint represent inaccuracies and violations of my responsibility, but it took away most of the complaint.
Mr. Schwartz, you said you share a last name with a lot of the players in this case. Are you not the Frederick Schwartz who drew the cashier's check in the amount of $12,000?
I am indeed Judge Shanker.
Okay, so it's a bit odd for me to ask you this question as both the attorney and a participant in the case, but, and I don't know if this is relevant to any of the issues on appeal, but can I ask why that check was written in the name of a person who had been at that point deceased for several years?
Your Honor, at that point, it was a transfer closing out the trust fund, which were given to the deceased individual. And it was used to, it actually came from a trust fund and it was used to settle the estate. And it was just a transfer, which was appropriate, which was, and that is in fact the only thing I can remember. It may have been error on my part that I received it and didn't do anything with it. It may be that it was mixed with something else and should have been cashed and wasn't, but that's the only exclamation I can give you. I have to say in all honesty that I do not remember why it was not cashed. My understanding, which has now been corrected, my understanding of the purpose of the cashier's check is to represent cash. And that it's, if it had been for $1,000 bills, then there would be no question about the delay in where they went. But in answer to your question, I just don't know.
Mr. Schwartz, I've been puzzled by what I agree with you. Cashier's check, is supposed to be a very reliable instrument. It's as good as cash. That's why it's used in, closing real estate transactions, all of these things. And at that point, when you request the check, presumably the bank went to the special needs trust as a remitter, saw that there were $12,000, took $12,000, put it into the bank's own account and issued the cashier's check. That's my understanding of how this works. Perhaps Appellee's counsel will correct me in that kind of simplistic explanation.
That's essentially how it worked. A request was made.
Right.
And I believe it because we were closing out our relationship with the PNC Bank. And that's why the check was issued for $12,000. And it was meant as a way of transferring funds in that account to where I believe they were.
So the $12,000 in essence closed out the special needs trust account?
I believe so, except for a very small amount.
Okay. When you present the check some years later, try to deposit it, I guess, or however you try to negotiate it, it's not honored right? This is where it says not authorized, dishonored.
Well, yes, it was dishonored.
It was a dishonored cashier's check, which you would think is, it's a breach of what the bank is representing on the face of the check.
Well,
But you did, that is not really, that would have, seems to me to have been the most direct way to challenge the bank's actions, but that's not the way this complaint is structured. Was that because there's a statute of limitations problems with doing that?
No, the complaint was structured in the way it was because it was a double complaint. First of all, not only was a cashier's check issued by the bank, but the cashier's check was, the request for the cashier's check was by the bank itself, by the trust fund. So the trust fund went to the bank and said,
But that's not the bank itself. The
No.
trust fund,
it's not the bank. The trust fund is part of their money management system. And
the
that.
trust fund is part of, that's one of the things that's not entirely clear to me. The special needs trust has an account or is managed by the bank.
It's managed by the bank.
But the bank is not the trustee of the fund, because you are.
That's right. And as I pointed out in my papers, full authority to manage and deposit money and withdraw money belong to the management entity, which is a separate entity.
I'm sorry, so the bank, this is the AM something at the bank, they could actually disperse?
They were the only people that could disperse.
Well, but at at the trustee's instruction.
No, they could disperse.
So what was their what is their status vis-a-vis the special needs trust? What is the status of the bank vis-a-vis the special needs trust? Other than just, that's where the money, that trust money is held.
No, they're struck in a in the kind of money management account, which was something or other, as you point out. Their agreement was, we will take your money. Excuse me, we will manage the money. We are the only people who can disperse the money. And we will have all rights to deal with that money. You can request us to do something. And presumably they could say, no, we don't think that's consistent with what is charged, or we don't think that that's appropriate. But they will, and as I point out in my papers, and in my complaint, they had 100% responsibility and 100% management.
There is a trust instrument that names the bank.
No, the trust instrument doesn't name the bank. I was a trustee, but as a trustee, I had a right to enter into an agreement with the money management.
Sure.
So is that agreement in the record?
That's all in the record. And if you look at the attachments to my opposition to summary judgment, you'll find bits and parcels of that agreement, but enough to indicate it. And I also indicated it in my complaint.
That there was
That they had 100%. It wasn't a bank account. It's not like I got money and I put it in wasn't a Geiger situation. I believe it was Geiger. It was a situation where they had total control over it. I don't believe there were any deposits made to the trust.
So what was the
but-
advantage to the trust in you doing that? This is kind of my curiosity. Were they investing the money and trying to grow the trust for you? Is that the impetus behind this?
Exactly. And they had a right to buy stock and sell stock and trade stock and turn it into ready money.
But the agreement let them substitute their judgment for the judgment of the trustee and ultimate disbursement to parties outside of investment?
Right, they never had to consult with me about anything.
Well, about how to invest the assets.
Right.
Yeah,
And-
but not in terms of disbursements to beneficiaries. What's permissible, what's not permissible under the trust?
No, the way it worked is that I could request from them that they deposit money in a special account which was used to pay for the beneficiary of the trust. There were actually 3 trusts. And in each case, there were beneficiaries. In each case, I would say, please deposit or please wire to the Chicago Bank or some other source X amount of money. And then they would in fact disperse that money in a wire bank to bank.
But that's you making the decisions and instructing them to move the money around in certain ways.
Or they could say, I really think that investing in a new convention center for the District of Columbia is a really good idea. And so we're going to put $100,000 into bonds for that. They did in fact shift it around, for which they received a fee
Mhm.
and not insubstantial fee.
And you're saying that because they did that, so how does their fiduciary obligation arise from that?
Their
In your-
fiduciary
yeah.
obligation arises, as I point out in my papers, not from the bank, but from the nature of the trust that I did put in the bank. So that it's like if I loan Judge Howard $1,000, then that's not a relationship with the bank. The point is that it's clear that the relationship was not with me. The relationship was a money management account where they had a certain amount of money. And they in fact had the same kind of relationship that Watergate West had, for example.
Is what you're really trying to allege that this is a trust for the trust?
Well, I wouldn't go that far. It's more a relationship where you have, for example, a partnership in a law firm. And the partners have a fiduciary duty with each other. And that's not, and that's what it arises from. There are situations like if I had my bank account at the bank, my bank account, LYNNE Schwartz's account at the bank,
Mhm.
that there's no fiduciary duty there. I make a deposit or a check. She makes a deposit, she draws a check. So there's no fiduciary duty. I agree with the judge in that regard, but this wasn't that situation. The situation was, it was a contract that they in fact would manage the money. And that includes as part of their responsibility to manage the money, not to steal it.
Well,
And
tell me, counsel, if what occurred here, and I get the feelings around this, and it seems very much based on the papers, like you were jerked around a good bit. If you'd been told immediately upon trying to cash that cashier's check, however many years later, this money was cheated under law to DC, and so you could have immediately gone to try to recover that money, would this still be an issue today?
no case. And in fact, right now, our position is that it wasn't a full conversion. What it was is for 4 years, it wasn't a matter of being jerked around, they just lied.
But I mean, once you were informed that the money had cheated to the district, why, I mean, you were still able to reclaim that money at that point, right?
The assumption is I haven't done it just because I'm the only one that isn't in all the pieces of paper that relate to that account. So, but the answer is yes. From the time that I asked for it, which was after it had been escheated, from the time I asked for it to the time they decided 4 years later or so that they were going to tell me where it was, I have no case. There are no damages involved in that. The only damages which are which are there now are those which relate to, and we're only talking about the cashier's check right now. The only damages that I'm entitled to are the ones that arise from that 4-year period.
For the delay, right?
Exactly,
You lost the value of your money for,
for 4
so
years.
for 4 years.
Yeah.
Plus, you had to file this lawsuit to
Well,
try to, no?
filing the lawsuit was just the beginning, Judge Reese. And that's all I'm asking. In that, but there are other bases of it. I think and as you all know, because you've all been lawyers, the main question you always ask your client are what are the damages? So the damages, even though there have been breaches, the damages are subsumed within that partial conversion. So they do not exist in essence.
And you never received any notice from the bank? Any
No.
written notice about these funds having cheated to the district?
No, there's a very involved statutory and complicated responsibilities on their part to have done that. They didn't. And not only didn't they do it, but the process where they should have done it, they said, we can't find that person. The pieces of paper they had, which determined their responsibilities, and they are in the record, right on those papers, in 2 positions, it said the other owner of the cashier's check was the LYNNE Schwartz Trust. And they just ignored that. They ignored it because, well, I think that's probably unfair. They do a lot each year, and they just went over it quickly and decided they had no responsibility to check the other owner of the check. They only had a responsibility to send the money to the government. And in that would be the reason that there would be, but there are no damages resulting from there. The only damages that resulted from that violation was the fact that they knew, or the only thing information is that they knew and by negligence decided not to send that notice that you referred to and comply with the statute. And
Let me ask you, because that begs kind of the question, if a cashier's check is supposed to represent cash, why did they need to check on who the original owner was if that cash was intended to go somewhere else? And then to compound my question, where'd they get the information for the sender, or where it was supposed to go to?
You'll see in the attachments to the opposition to summary judgment, they have a very involved list of responsibilities, who it's to go to, where it's to go to, everything's computerized, who's to go to, where it's to go to, what they have to do to comply with the statute. And one of their responsibilities is sending the notice, and I believe there are 2 forms of the notice that go out. And they also have a responsibility under the statute to do some kind of an investigation if they can't find out who it is. Their position is that, well, the top name we saw was Francis Schwartz, and we had no information about any Francis Schwartz.
I guess what I was really trying to ask you, I've read the record and there's a lot of information in there. You were on both sides of this, right? You were representing the estate and you were the trustee for the trust that this was coming from. Did the information come from you that they were relying on for where to send it to?
No, it came from their computer.
How'd it get in the computer?
Oh, it got in the computer because they keep a close record of who gets what. In this case, it was more than $10,000. So they were required to notify, make certain notifications relating to it. But they're required to keep officially for 7 years, although I believe they keep the record for 10 years for tax purposes. They, at the end of each year, they have to do a 1099. I believe that's the number. And that's where the responsibility arose to Tower. And they have not contested that. They of course said in their answer that I have to prove it and look it up and it's my responsibility, but technically it's their responsibility.
When the judge, you starting, come back, you said that you thought the most important issue or the most serious error by the trial judge was denying your motion to amend the complaint, right? This is where you started out, and the judge denied the motion to amend, saying, I don't have any proposed amended complaint to look at, so I can make a determination whether I should grant or deny this motion. When the trial judge denied the motion, did you say, okay, judge, if you need to see it, here it is, or I can provide it to you, or?
Well, that is the procedure, but if I had an opportunity to ask for a reconsideration of the denial, I could have. That issue was raised by the bank. They said, we haven't seen it, you haven't given it to us. I'm not responsible to provide a copy of the amendments to the complaint. And in fact, I couldn't, because I also asked for further discovery in the papers that I submitted in my motion. And the reason I didn't give them any more is I just didn't know. I would have to do further research. I would have to find out what the bank did and find out whether it was a problem with the bank.
So you asked for discovery in aid of amending the complaint?
I asked for both together. When you ask to amend a complaint, it is not necessary to provide the amended complaint as long as the purpose is clear and how you're going to amend it. And I, in each instance, provided, and my motion isn't with a rather large record. In each instance, I provided the request for why, how it is that suddenly everything I said in my, not everything, but a lot of the things I said in my complaint were untrue. And what was true is that instead of a full conversion, it was a partial conversion. And I had to address that issue. And basically, the purpose of litigation, as this court has said so many times, they're probably unhappy about having to repeat it. The purpose of the litigation is to resolve the issue with the spirit of justice. And that is why discretion, when it's exercised, even a small deviation in the discretion, is enough to have this court reverse it. Now, I don't get anything from what this court is going to do right now. The reason I said what I did is because I would think that the court would say, okay, she should have allowed the amendment. So we will send it, we will remand it back. We will make no judgments as to what the circumstances are under the new case, under the new complaint, because they will have a right to answer under the new complaint. They will have a right to have the consumer provisions apply under the new set of circumstances. They will have every right, I believe, that I've mentioned that matter as to the cashier's check. As to the other two matters, those are just strictly summary judgment was improper. But as to that issue, which I think is the critical issue, the court consistently, because it can't tell what a jury is going to do or what a jury is going to say or a fact finder is going to say under circumstances which were so different that in fact well, this court just has never really done that. The court has done it only if, well, we could send it back, but we know what the result's going to be. Say the statute of limitation ran. So she made a mistake in the statute of limitation. She didn't read Judge Shanker's very exhaustive review of COVID and the statute of limitations. So we can decide that issue now. I'm not asking the court, and I don't think it would be fair to ask the court to make that kind of a determination. I think this court, in passing, there were certain legal decisions she made, and the court might mention it. Judge Reese, you may remember in the Dargan case, where you sent it back and said, there are so many problems with this case, I don't even know what to do except to ask all the questions that nobody bothered to answer. Or the administrative judge didn't bother to answer. So that would be the remedy that we're asking. So it's going to go back. And because it's January, happy January, where all the judges change, there will be a different judge. And it's almost as if what's happened before doesn't matter.
If there's no further questions, thank you, Mr. Schwartz. We've reserved your time. Mr. Danziger.
Thank you, Your Honors. Good morning. May it please the court, Philip Danziger from Reed Smith on behalf of PNC Bank, the appellees and defendants below. I'm not quite sure where to start, other than I agree wholeheartedly with counsel that this is a bit of a bizarre case. We also agree on a lot of other things, such as the standard of review applicable to the underlying decisions, as well as most of the salient facts, which are essentially that in April 2015, PNC issued a $12,000 cashier's check at counsel's request. 3.5 years later, PNC legitimately, as counsel described it, escheated that amount to the District of Columbia. And approximately 4 years after the check was issued, counsel sought to deposit it. And the main issue that counsel has, or the parties I should say, is with PNC's initial explanation as to why that check was dishonored. Initially, PNC accepted it. 3 days later, it notified counsel as the trustee that it was dishonoring and debiting the funds because it was, quote, unauthorized. And that is the crux of the complaint here, is the explanation that was given.
And at that point, with no further explanation, was that a breach of the bank's obligations with respect to the cashier's check?
We don't believe so, Your Honor.
Well, you dishonored a cashier's check drawn on the bank,
Correct.
and the banks are not supposed to do that?
If the funds had not yet been escheated, the bank should
Well,
not have done that.
no, at that point, we don't know about his cheat, about any of his cheat. He just said that. He doesn't know what's happened.
The depositor did not know. The bank presumably at the time
You
didn't know.
would think the bank would know, right? It's kind of distressing, I have to say, that $12,000 cashier's check is not honored by a bank that issues a cashier's check, can't tell you Why?
Well, I think actually the bank did what it was supposed to do. It
Which
initially
is?
accepted the cashier's check.
But then it
and
didn't.
Credited, the account with the funds for it. It did its investigation as it was supposed to do. It realized that the funds were no longer where they were supposed to be for one reason or
But
another.
where was, okay. The overlap between the cashier's check and this cheating obligations of the bank is unclear to me how those two things work. I mean, when you look at the cashier's check, it's just a cashier, it has no expiration date on it, anything like that. So what would have kept Mr. Schwartz at that point immediately from saying you've dishonored this cashier's check? Not you owe fiduciary obligation, whatever, you've dishonored a cashier's check. You owe me that money.
That is essentially the claim at issue here, Your Honor. Not quite sure how to respond to that. Our position is up until the point that it was escheated while the funds were still in the possession of the bank, that absolutely we had the obligation to turn it
honor.
over.
But that once you had another obligation, which was to pay that money over to the district, then the cashier's check just becomes kind of null and void.
I would say there might be a
Are there any
window
cases on this?
on.
Oh, this
escheatment.
one, yeah, on what happened here?
So I would say, I think that there might be a window where once the obligation to escheat arises, but before the escheatment has actually occurred, there might be competing obligations. But once the funds have been escheated and are no longer within possession of the bank, that no, Your Honor, they no longer had that obligation.
But is cheating done with respect to cashier's checks? I mean, I guess that's the,
It is, Your Honor, and that is exactly what happened here.
No,
As we
that's
provided,
it's in the statute, right?
yes,
Talks about, although there doesn't say, as to cashier's checks, it doesn't really say when it's deemed to be unclaimed property, right? Not specifically, is that correct?
not specifically, I don't believe with respect to cashier's checks, but they are dated. And property of that sort is presumed to be abandoned under the act.
Yeah,
under the
but
Unclaimed
when-
Property Act
when?
Within 3 years.
But that's what I was getting at. Traveler's checks, it's like 15 years.
I believe so. I'd have to check, Your Honor.
Yeah, and kind of odd that cashier's checks would be so much less. Are there any
We
cases?
just follow the law.
Well, no, but the law doesn't, it's a basket provision, right? It's a catch-all provision. Are there any
We,
cases?
we have
Says
not
this is where
specifically on
cashiers-
this exact situation. We have not found any of that. But I
But
think
at
it's
this point, it's cheated not only after that extended time period, but after the underlying trust account closed, so there was not a trust account to put it back into.
that's correct.
Was that part of the calculus as you understand it from the bank's perspective?
Having learned after the fact, that is my understanding.
But this is
and-
all outside the record at
Correct.
this point.
As
So I
the
guess
motivations.
one of the questions really is, why was there this long delay? Because as Mr. Short says, this is, whether you call it conversion, whatever. He didn't have access not only to the money, but to an explanation that might tell him where he could go find the money for a long period of time. And there are notification requirements on the bank when something is escheated, all that. I mean, from what I have seen, it sounds like something went really wrong here.
So admittedly, there may have been a bit of a disconnect when the check was finally presented for deposit. I think it's important to note that even counsel and their papers describe the escheatment as legitimate. I mean, there's no dispute about that.
Right.
Um,
No, the case is about what obligations does the bank owe to the customer, or to the representative of the customer.
in terms of the explanation given at that time or
Yes, I
upon
mean, you put
escheatment.
money in the bank, you ask for a cashier's check, you get it, and then poof, it's gone.
So the bank did, of course, have notification obligations, which counsel and below complained about, that they are unsatisfied with how we went about trying to locate the apparent owner. But there's no dispute that those efforts were made. There's no dispute that the current address wasn't within the bank's records, and that only afterwards was it produced in discovery by the plaintiffs.
This is the Francis Schwartz,
Correct.
yeah.
But ultimately, there's no dispute that the bank made every effort that it was obliged to make to locate an apparent owner of the funds and was unable to. So whether the bank had an obligation to, of course, it believed it was giving a truthful explanation at the time when it was presented for deposit as to the reason why it was being dishonored. There may have been a little disconnect there, but there's no dispute that the underlying achievement, the reason why the funds weren't available, was legitimate. And while I understand counsel and the underlying parties may be upset about the explanation and are a little bit frustrated by it, that's not a cause of action that I've heard, made out.
Not a cause of action when there is assuming, well, what you call a little bit of a problem or a disconnect could also be kind of you don't think that could amount to a breach of the bank's obligation to the representative of, well, either the trustee of the remitter, right? Obviously had an interest in, that was a bank, that was a customer of the bank, right?
Correct.
The special needs trust.
Yes.
I mean, that was on the face of the bank, the check.
The bank certainly had an obligation to act in good faith, which
Right.
is our position that it did. There was no intent to mislead as to the explanation.
Was there any? I know that there was an explanation as to why the payee, Francis Schwartz, couldn't be found. But what about the special needs trust as the remitter, the original owner of the funds
I'd have to.
and customer of the bank?
To go back exactly onto the record as to the nature of the search that was done. Again, it's in the record and it's undisputed. The steps that the bank did take to locate the apparent owner of the funds and was unsuccessful. And again, it's not disputed in that regard.
The current owner of the funds? No, I was talking about the trust.
The LMS trust,
The special, yes.
it was a client or customer of the bank, but again, of all the, could they have taken an extra step? For purpose of this argument, sure, I will concede that they could have. Were they obliged to? No. They satisfied their obligations with respect to trying to locate the account holder and they were unsuccessful. And
by the account holder, you mean the payee?
the remitter. I'm sorry, yeah, the payee, sorry.
Yeah, no, the remitter was
The account holder from
the
where
LMS.
the funds were drained.
Yeah.
But I guess on the other couple quick points, while I still have a few minutes. We heard a lot about the potential fiduciary duty and whether there was one, and certainly here there was. I mean, everything that you heard described was a quintessential depositor-bank relationship. And the mere fact that the account holder was a trust does not, create a trustee of the bank. And there's certainly no authority presented for that argument. With regard to the amendments, again, abuse of discretion standard, no abuse has been described here. Council certainly could have presented a proposed amendment. There was none presented with the motion. The court was aware of the circumstances giving rise to the request, namely the new explanation that was discovered during discovery, which, although counsel takes issue with, he also readily admits he can't remember the circumstances surrounding. But apparently the bank is held to a higher standard in that regard.
Well, if, as you say, the trial court was aware of the new circumstance and new evidence that had come to light, which prompted the motion to amend the complaint, why would that not have been enough to, for the judge to make an assessment?
I believe it was enough for the judge to make an assessment. Understood. So counsel could have presented the proposed amendment, which of course would have given the trial court the best opportunity to assess the futility or not of the proposed amendment. But independent of that, the trial court was also aware of the facts that gave rise to the request to amend, and even considering that, determined that any amendment would be futile.
Well, no, I don't think the court, correct me if I'm wrong, I don't think the court said that an amendment would be futile. It just said that it didn't have the basis to assessed whether the amendment would be futile. And that is, I mean, I'm not sure that's right. If there's no requirement, explicit requirement to attach the amended complaint itself, I mean, I agree that our cases say that the court has to have some basis to evaluate the merit of the amendment, but it seems like you're conceding that there was some basis to evaluate the merit of the amendment.
So to the point that the court's holding was limited to the lack of an ability to determine, to judge futility or not. That was certainly, the four corners of the holding and won't suggest otherwise. But certainly the court had all the facts, before it, and there was nothing within that the court was able to, parse to come up with the cause of action. So while it was not the basis for the holding, certainly was within the record.
So you're saying that without a proposed amended complaint, based on what the judge knew, was told about new information that had come to light, the judge, based on those facts, alleged facts, could not think that there was any possible cause of action?
Well, I don't think it's the trial court's obligation to, find the cause of action within it and do counsel's job for them.
But there is this notion that, motions to amend are granted, kind of generously. There are new facts that have come to light from the bank. So for example, if certain notifications were not given as they were supposed to be given under law, I mean, there would have, I don't know what the cause of action would be, but it's not, impossible to think of something.
Reasonable minds differ, I suppose, on that. Again, I'm not going to argue and suggest that, the trial court made its own independent determination as to futility based on everything that it knew about the facts and changed circumstances.
But all the trial court said is, I don't have an actual document, I cannot assess, denied.
That's right. And that's all I will argue here. But, I would note just anecdotally that, based on that, and certainly the liberal amendment standard, that with knowledge of the changed circumstances, that if the trial court could have divined any possible cause of action, that would have been the opportunity, as you say, to let him, amend. And the trial court determined that it would, not be within the interest of justice.
If there's no further questions, Mr. Danziger, thank you for your argument.
Thank you, Your Honors.
Mr. Schwartz, we'll invite you back up.
I accept. Let me say that, as counsel pointed out, most of the facts are clear here. And the violation of law that took place here is also clear. It wasn't that they cheated. It wasn't that they, although negligently, provided the report or whatever you wanted to call that money, which was represented by the cashier's check, to the District of Columbia. And as Judge Reese pointed out, it would have only taken moments, or at least that was the bank's position. Look, we don't know anything. You can just walk right over to the district building or whichever place they have the depository, prove who you are, and they'll give you $12,000. So there are no damages here. We didn't do anything wrong. But here is the issue. Not only did they say not that we cheated, or not that we're not sure what happened to it, or not that it's not authorized. Whatever it was, they said this is not authorized, which means the check is not authorized. It doesn't mean, well, we gave it to the government. And not only did they say that, but for 4 years since the request was made, and presumably when the request was made and the complaint was made, there was an investigation, and in the complaint it points out that contact was made between the bank, between responsible people in the bank to determine what occurred. The point is that not only did they not answer, they went into the most extensive litigation that I've seen on any case, even for hundreds of thousands of dollars. Not, but not $12,000. And if you look at the record is amazing. And you start with the answer, and the answer said nothing. The answer said nothing about achievement. And then there were a number of other motions that were made, which ours were not granted by the judge, and theirs were granted by the judge. But I mean, heavy litigation, not just, perfunctory litigation. And it was meant so that the case would not be pursued. If the case was not pursued, the $12,000 was not available. There was no reason to think that that money had been escheated legitimately. Not by the wording, and I've included it in my paper as a brief listing from thesaurus of what authorized means. It wasn't the right term. And one would have hoped that in a bank, significance, and a law firm of significance, that somewhere before they went through all this litigation, that they had determined that it had been escheated. And certainly not just as we were about to get organized for trial and do a pretrial. That it wasn't then. What they tried to do is make sure that no further investigation took place. And that is why this case was continued. And if you look at my papers, it was thoroughly researched. It wasn't that I just sort of decided that I was being jerked around, as I think Judge Reed said. It was because there were serious issues, and those issues are not just in this case. Those issues are in the way that that bank has determined that it is going to litigate when they're wrong, as well as it's giving up when they're right. And now this is not the time for counsel to say, well, yes, they should have told you. This is the appeal. And but we agree that this case has nothing to do with $12,000 anymore. And $12,000 is not asked for. The only remedies that are available are the remedies of partial conversion and that subsidiary litigation, where the only really interesting issue is when in fact, or whether in fact there was that strange order, and I've included the site, but the COVID order amended 7/29/2022. And I have no idea where that came from. And Judge Shanker, who went so far as deep diving that issue that he might have damaged his head if he wasn't lucky. Everybody seemed to assume that it was a different date than the date in the order I had. But I can give no credence to that order except that my computer works. So if there are no further.
What are the remedies for what you call the partial conversion, which as I take it is a 4-year period that you didn't really know what had happened or why the cashier's check was not honored?
In terms of the cashier's check, my only damages is the damages that I could have recovered from having that $12,000 for 4 years to the cost of finding that for that $12,000 and 3 violation of the consumer protection statute. Because I mean, that's a stock and trade of the bank. The bank says, I am honest. I deal with you fairly. I deal with you efficiently. I don't do anything with your money we shouldn't. And they violated all of them. and they advertise to the contrary. Thank you very much.
Thank you, Mr. Schwartz. The case is submitted. We'll give the parties a brief moment to change places, and we will hear next number 23, CO 1044, Blackmon v. United States. Ms. Daniels, welcome. Would you like to reserve any time for rebuttal?
Thank you. Yes, Mindy Daniels for the appellant, James Blackmon, and I'll reserve 3 minutes for rebuttal, please. Here's why Judge Anderson's order needs to be vacated, which is subject to this appeal. We claim that the court abused its discretion because the order only considers items 1 through 6 in his pro se motion that he claimed would exclude him from the rate. That's the comforter, the towel, the pajama pants, things that were collected at the crime scene. So if we can just divide it by saying items 1 through 6, things he wanted tested, items 7 through 10, the retesting, okay? But the order only deals with 1 through 6. And it only deals with 1 through 6 because the judge said that he withdrew his request for retesting under 7 through 10. The problem with that is that, and the reason why these things are intertwined is because the court then allows that to influence it in its decision-making on 1 through 6. And if the court would indulge me, I'd like to give specific examples of the prejudice. I know we have other things to unpack with regard to his letter, but how it intertwined itself and how they're related and the prejudice is throughout the order. Page 3 at the top of the order, the court says, notably, the defendant does not seek retesting of the very swabs that are the most powerful evidence of his guilt. Instead, he wants these other things tested. And then it goes on to say, as the government points out, the probative evidence of such tests dwarfs in comparison to the evidence of the DNA that was discovered in the victim. Then the footnote on page 3 talks about, excuse me, the withdrawal of the request. I don't need to read it. It's a footnote. Then on page 6, the second indented paragraph, the court says, I agree with the government that the most probative DNA evidence is, of course, the testing done on samples taken from the victim's body. The probative value of the items, the defendant requests to test, the towel, the comforter, items 1 through 6, is minimal in comparison to the evidence of the defendant's DNA found inside the victim and would not undermine confidence in the outcome. There are 2 other places. Page 7, and it's only an 8-page order. The premise of counsel's argument referring to whether counsel is ineffective and can't remember why he didn't test is misplaced. Even if testing items 1 through 6, they would not exonerate him because the DNA that was tested clearly identifies him as the perpetrator. Page 8. This is the last one. The defendant's theory that if he were excluded as a contributor to the DNA on items 1 through 6, he says it raises doubts on the veracity of items 7 through 9, and that's not enough. Now, his letter to the court.
Why does it raise doubts on the veracity of 7 to 9? I kind of like, your points are well taken, and I think it's pretty obvious, even from what counsel was putting in, that he wanted the retesting. Even if we're not considering the letter that could be classified as ex parte, but kind of, and going to channel our former colleague Judge Fisher here. As I was reading, I just kept thinking, so what? I mean, if his DNA is not present on these other things, why does that negate his DNA being present in the victim?
I'm sorry, did you ask a question? I'm not sure I heard
I
that.
did. It was, I said to channel Judge Fisher, my thought was, so what? Even if on 1 through 6, he's excluded, his DNA is not found.
Right.
I understand his theory. Why does that negate that in this situation of stranger rape, his DNA was found present in the victim on 7 through 9?
Well, that's why it was so important to do both. And that why he wanted it retested. And that's why his letter, actually his letter to counsel, it's only 2 pages. He says, you withdrawing, I never gave you permission to withdraw. You withdrawing it hinders my case. And he actually set forth in his letter how it would hinder it, which is exactly the way the order wound up. I can't just say I'm excluded with the retesting. I have to also show, that he was saying, in comparison of importance, I need the retesting, with these new tests that he claimed, but we never got there, because we never got to, whether.
Yeah, so the opposition challenged the.
Right,
New
we
test
never-
didn't show anything whatsoever, but.
Yeah, I
at
mean,
the
it was.
Point that it was withdrawn and the judge didn't consider it, you didn't have findings.
Right, it was brief, but we never got there. So, what he was saying, his fears and why he did what he did is exactly how it played out.
But counsel, I
in
mean,
the
I
order.
I agree that the trial court looked at 1 through 6 vis-a-vis 7 through 10. But I mean, let's say the trial court didn't do that. And well, let's just say, let's take 7 through 10 out of the picture. I'm still not sure 1 through 6, the absence of DNA on items 1 through 6. It might be probative at trial. The question now is under the IPA is whether it goes to actual innocence. And I think we've said that the absence of DNA on items doesn't actually go to actual innocence, right? I mean,
Well, I think it's important in this particular case, these particular facts, because there was no identity by the complainant, even though she described in detail significant time with the person. There was no identification of him. So everything was about the DNA.
And she was shown,
And one,
I'm sorry, she was shown an array with Mr. Blackman on it, and she didn't identify. Is that
I'm
correct?
sorry,
She was shown an array with Mr. Blackman on it, and she did not identify him. Is that correct?
right, she didn't identify him before, during, or at trial, even though she testified at trial, and she talked a lot about what occurred between her and this person. It started with someone knocking on her door and asking for where the landlord was. I mean, it sounded like it was a pretty significant amount of time. The terrible things the perpetrator did, take the shower. And that's one of the things that he brought up in his pleadings was the reason why 1 through 6 is important is his theory, that we never got to, is that because the DNA could have been corrupted by this intervening event of the shower. And, that was part of his point, why 1 through 6 would be important in this case, and including the fact that, supposedly the perpetrator touched these things, and yet, now what happened was, just to unpack some of the facts, as the record shows, these things that we're talking about 1 through 6, they did go to a lab. I mean, I think it was Judge Dixon, permitted it, and they went to a lab, and then counsel didn't follow up is what happened. He can't remember why he didn't follow up, but he didn't. So the things weren't tested. Now, the government, Judge Shanker, agreed with you that, oh, well, we don't need to test these things because we have, these other things to get him on. And so we don't need these other things. In fact, it would help him, perhaps if we did DNA testing and, there wasn't anything on him. So, is DNA testing available for these things? Sure, you can do garment DNA testing. The government has never claimed that even the swabs that were tested, that they are not available anymore, that they've been used up. So that's not really an issue. But for the vaginal swab, maybe. It's a little unclear to even me. Whether there was a fraction, I don't know, the government talks about it in its brief, some fractional amount or I don't know, whatever it is. But, but this occurred in 2008. So we're going pretty far back. And his trial was in 2009. And then he had another trial. And then in 2013, they tested the rectal and the buccal swabs. So, and again, it's not before the court, but, the progression of DNA and testing ability. But again.
Well, let me ask you about that, because in your brief and in previous statements by both the appellant and previous counsel, they talk about the newer technology would help with better identifying things where there's a DNA mix, not unlike some of the articles that he cites in his pro se motions, but that's not really an issue here, is it? The only DNA found was the victims and his. And so I don't know if that's even really kind of prima facie, if I'm looking at it without the trial court having gone into it below, if I need to look much further, if the problem we're talking about is not the problem that these new tests solve by argument of the appellant.
Well, Your Honor, with all due respect, that Judge Anderson did not rule on that. So, I didn't spend time, saying, well, this particular test compared to this particular test. And even though, it says it was a two mixture, as opposed to a
But that's a
greater.
point in the record, right? That would be fair for us to consider.
Well, he asked for it and he briefed it, the government briefed it, but the court never got there. The court could consider anything the court wants.
But as we're looking at the harmfulness of this.
Well, but the harmfulness of it is, he wrote a 50-page pro se motion. He asked for two things, okay? The court only ruled on one of them and then used against him the supposedly that he withdrew the other testing. So, the claim on appeal is that the order as it stands, which only deals with 1 through 6, it doesn't even mention the testing, needs to be vacated. And the remedy, the fairness here would be for the court to vacate Judge Anderson's order, send it back, and she has since retired, let another judge determine both, so that the 1 through 6 that we're claiming was infected by supposedly, which he didn't withdraw or waive, the retesting 7 through 9. So there wouldn't be that infection anymore in the record.
And so are you saying the avenue to get there isn't just ineffective assistance of counsel, but because the trial court had Mr. Blackmon's pro se motion before it, it simply erred in not considering his request?
Well, could I bring an ineffective assistance of counsel motion? Sure, I can do that. I haven't done that yet. You can.
But you've argued it on appeal that it was a function of ineffective assistance of counsel.
Well, right, because that fit into the IPA, the IPA statute and why certain things didn't happen.
No,
So,
that's a
because
separate.
He was claiming
That's a
that.
separate ineffective. I'm not talking about why items 1 through 6 weren't tested before the first trial by trial counsel. I'm talking about Ms. Block's retraction of the request to test items 7 through 9 in the IPA litigation. I thought you were arguing on appeal that that was ineffective assistance of counsel. And so holding by us would be the way to get, to get your
Yes.
requested reversal or vacator of the, yeah.
Yes, that was an alternate theory, yeah.
So it's
that
alternate.
ineffective and the conflict of interest.
Right, but so you said it's an alternate theory. What's your primary theory? That the trial court simply erred because Mr. Blackmon had himself
That it-
moved pro se for testing of items 7 through 9?
Well, that he had all this, he argued what he did pro se, and that the court heard because that was still before it, and it didn't consider it, and then used it against him. I mean, that's another
Without
argument.
getting into ineffectiveness of counsel and by counsel, I mean, IPA counsel, right? And by the way, is there a procedure on, how would you bring an ineffectiveness claim against IPA counsel?
How would that go?
Yeah, under what, does the IPA allow for that?
Well, I mean, it would even include Ms. Reed, actually, the second one.
Right,
The,
because she was informed of the letter that was sent.
right,
Yeah.
and I do want to,
No, but what's is it 23-110? Because when I look at the language of 23-110, it doesn't quite fit.
the 23-110.
Yes, what's the vehicle? What's the vehicle for alleging ineffectiveness of IPA counsel? Is it in the IPA statute? Is it just kind of, I don't know.
No,
You just ask the court for a hearing?
I think that it would have to be, I mean, I mentioned in the brief that the court should have sua sponte done a Monroe Fowler thing. I'm willing to concede that it would be a 23-110 motion. So it
Well,
would
but
be the subject matter of,
does this fit within 23-110 is my question. Is 23-110 a proper statutory vehicle to bring a claim against IPA counsel? It's a question. I don't know.
yes,
It is? We've said
yes, I
that?
believe so, yes.
Right.
And it would be, she withdrew it for specialized counsel, but that specialized counsel didn't really, as a factual matter, exist. Until, they talk about the Innocence Project, but until, the Innocence Project enters an appearance in a case, nothing, it doesn't mean anything.
But I have again, without getting into was there ineffectiveness or not, just in the base of what was before the trial judge. Judge Shanger has brought up that one of the things that the judge had was the pro se pleading, right? Which pressed the retesting of 7 through 9. Now, I don't know whether that pleading is supposed to go out the window once there's but the other pleading was a supplemental pleading, right? Not a substitution pleading. But the other thing, and you just mentioned it, is that Ms. Block said that she was withdrawing without prejudice, right? The retesting with respect to 7 to 9 because there was this specialized counsel notion that somebody else might be looking into it. So was it even appropriate under these circumstances, pro se pleading, this kind of withdraw without prejudice, which seems to suggest, no, that's not really totally out of the case, 7 through 9, for the judge to say, well, I'm not going to consider 7 to 9 at all. And in fact, I'm going to take the existence of the testing that has been done 7 through 9 to basically say, who cares about 1 through 6?
Right. That's what I'm saying. Yeah.
That's what you're saying.
What you just said is
Okay,
is what I'm saying.
all right.
And
So where's the
before
That doesn't matter.
where's the ineffectiveness in it?
where's the ineffectiveness? Well, first of all, the entire, in her pleadings, in what, she didn't do much, Ms. Block. What she did do is say, there's potential for ineffectiveness here, but she never brought the
Okay,
ineffectiveness
so that's the
motion.
ineffectiveness for the trial counsel.
Right,
So that was really interesting to me because I wondered, and I don't think we've really had a case in this posture that I at least noticed. Is that even available for her to bring? It strikes me that in a published opinion in 2019, I believe it was, we dealt with an ineffectiveness of counsel granted on different grounds brought by Mr. Blackmon. And it strikes me that if we were to have that actually come as a claim and it came all the way up on appeal, we would probably agree if a trial court said, this is procedurally barred as either successive or an abuse of the writ, because there's nothing in here that says he didn't know that this wasn't tested or shouldn't have known or couldn't have known back then. So I feel like Ms. Block was kind of hamstrung here, and one reading of the record is that she may have been hamstrung as well on that withdrawal without prejudice, because she made the strategic decision that this wasn't a good thing to go test after two independent agencies and the FBI had tested it. And I know I'm loading a lot onto what were the questions, but let's isolate the first one. Do you think that she could have even brought that ineffective assistance claim?
Well, I understand your point. I mean, in practice, people bring claims all the time that they may or may not win. I mean, her thought that, gee, I might not win this.
Sorry, can I stop us? I'm apologies to everybody for my tone here, but we're conflating multiple things here. And I think we're going down a weird path, because the question about items 1 through 6 was whether Mr. Blackmon could request their testing based on the provision of the IPA that allows testing of items that were not previously tested based on essentially ineffective assistance of counsel. It references 23-110. Okay, this is A3C. And so the claim was my trial counsel was ineffective for not seeking the testing of items 1 through 6. And that was a basis that the trial court considered Mr. Blackmon's request to test items 1 through 6. And
That's right.
I don't think anyone's questioning that. And I don't think the issue is whether Ms. Block should have brought a standalone 23-110 for trial counsel's failure to seek testing of items 1 through 6. It's already set forth in the IPA that Mr. Blackmon can seek testing of those items, essentially on an ineffective assistance theory, not through an ineffective assistance motion. Okay, then we've got a completely separate question of whether Ms. Block rendered ineffective assistance by retracting the request to retest items 7 through 10. And Judge Ruiz's question is, how is that sort of ineffective assistance litigated? And we don't know. I mean, you said it's 23-110. We don't know if that's right. I don't think that's ever been decided by this court. You dropped a footnote in your brief saying that once the statute provides a right to counsel and counsel is appointed, that implicitly it guarantees a right to effective counsel. And that might be, but I don't know if we've ever decided that. So I was asking you if a separate theory is that we don't have to go down an ineffective assistance of Ms. Block road, because Mr. Blackmon had independently pro se moved for a retesting of items 7 through 10. And I think your answer was yes.
Right.
Okay. So I don't have a question at the end of all of that. Just,
And I agree with your analysis and your thinking about that. I'm trying to answer
yes, I
questions that were
understand.
posed to me.
Right.
Not necessarily that I agreed with that road, but I agree with you that because that's under, what is it, 22-4133-A4, the ineffectiveness part. And he did very specifically say, I'm talking about ineffectiveness. In his pro se reply to the government, I think it's R-182, he very specifically said, look, I'm a pro se guy. I'm trying to do my best. So let me be clear. Yes, I'm alleging that ineffectiveness. He very specifically said that. And I know my time's up. And I know that I only have time to rebut what the government says, but there are some factual issues I think that are important to mention. I think it's unfair for the court to have said that he flipped back and forth between innocence and guilt. And in fact, he lost one of his appeals because he got on the stand at the 23-110 on the plea thing, and he completely balked and said, well, I'm not guilty. I would say I am because it was a good plea. It would just be what I heard. And in fact, he lost the appeal on all of that. And that is in the 215A3rd, 760, 2009. That's his case, Blackmon versus the United States. Also, Judge Ruiz, you were on the case after the second trial, the direct appeal. And there also have been made statements that he didn't challenge the DNA evidence at trial. And when you summed up the facts of the direct appeal, you said counsel argued mistakes were made in DNA testing. It was unreliable. There was an expired rape kit. A key piece of evidence was lost. The science isn't good. A new test could have different results. So to say that it wasn't challenged is not so. Also, page 4 of the order says that he said the results are invalid because the DFS conducted tests. He agreed with the government about that he made a mistake. That's on record 182, page 3 of his response. So he did take that back. I do want to again say that just because the Innocence Project even assigns an attorney, that never means that they're representing you. And also, the government says a lot about that this was an ex parte letter. All pro se pleadings are ex parte. Compassionate release pleadings is pro se pleading. And also,
Well, a pro se pleading is served.
Not
on
his
the
letter.
Other party.
excuse me.
It's not all pro se pleadings are ex parte. What makes it ex parte is that the other side is not notified.
Right. I mean, what I mean to say is that when defendants file in Superior Court, oh, and they made a point about it was filed with the clerk, that if you just send something to a judge, you have no guarantee it's going to be
Filed
docketed.
and requested that it be put under seal.
He requested that it be put under seal, which just means not public, because he was divulging an attorney.
But he actually asked for it to be put on the docket, right?
That's correct. He
So
did.
it's not, I mean, it's the opposite of ex parte.
That's true too. Good point. He did ask that it be put on the docket. And the just in the record, the court's response, his letter, that is all very concisely in the sealed record on appeal, the 11-page sealed record on appeal. You know, so we would ask that Judge Anderson's order be vacated, that, you know, obviously it would be assigned to a different judge. Let him have another attorney if they're going to file a supplement on the testing part, about whether, you know, that's viable, whether it's valid. Ms. Block never did that because she kept talking about specialized counsel. I'm going to leave that. I'm going to leave that. It never happened for him. So I guess what I'm arguing is that, you know, as a matter of due process, vacate the order, let him have another attorney downstairs, and, you know, let him have another bite at that apple. And, you know, for a judge to issue an order that's not infected with the thought that he didn't retest. And the other thing is that if the court is going to affirm Judge Anderson's order, then I think it's extremely important that the court specifically state that he has a right to file more pleadings or have counsel to do on the retest of the DNA, because if the court's going to go along with that, it was withdrawn without prejudice. The problem with the order is that it never speaks to that. It actually says order denying his pro se motion. He withdrew it. And he even says in his letter, hey, if I go back, they're going to hold it against me. You know, it's going to be a successive motion. I'm going to get denied on that alone. So You know, I would just ask that, again, that if you are going to affirm Judge Anderson's order, then he's without the 1 through 6. And if he's going to be left with the other part of it, he's going to need some help, and the trial court will need some help understanding that he has a right to that. Thank you.
Thank you, Your Honors. May it please the court, Catherine Kelly on behalf of the United States. Your Honors, in this case, the trial court did not abuse its discretion in denying Mr. Blackmon's IPA motion for DNA testing. He proffered only conjecture that DNA testing would yield exculpatory evidence, and therefore, regardless of everything else, he has failed under 4133D to show any requirement for testing. I think it's also important to note that there's no question that the defendant did withdraw his request for items 7 through 10. That was done in the supplemental motion back in July of 2022. This was not something new that happened in the reply by Ms. Block in August of 23. And all those decisions by Ms. Block that are being faulted now were made after investigation. In particular, the record shows that after Ms. Block was put on the case, she contacted the independent lab in Ohio that had done the retesting of the swabs before the second trial.
But I
She
mean,
got a
so
court
we,
order.
are you saying that as the attorney, she exercised her better judgment over her client's wishes and made a strategic decision to retract his request to test 7 through 10, and that should be honored because he's now counseled and he can't file a competing pro se motion? Or are you saying that that's a basis to find that, to the extent we consider this under the ineffective assistance of counsel lens, that it was a strategic decision that was and therefore not deficient performance? I mean, what's your view on how we are supposed to
When you
look
say
at this?
ineffective assistance counsel, are you talking about an ineffectiveness claim against Ms. Block?
Yes.
Okay, I would say number one, Ms. Block did her investigation. And it's important to look at that she did have the strategic ability, given that she was representing Mr. Blackmon, to withdraw arguments that were not good. And I would note particularly that as Ms. The trial counsel or defense counsel has said just now, the reason that Mr. Blackmon in his original pro se filings said that he wanted retesting of the swabs was because he thought the DC crime lab had tested the swabs, which was, he believed that DFS had been involved. That simply wasn't the case. The government pointed that out in responding to his pro se filings. And even in his pro se reply, Mr. Blackmon recognized that DFS had not been involved in his case. So for Ms. Blackmon then to say, I am not seeking retesting, not only there wasn't a valid reason that Mr. Blackmon still had on the record for why the retesting should occur on the swabs. And second of all, she consulted with the lab in Ohio to, she got a
How do we know
court order
this? Was
for
this
them
in
to
her,
release their records.
was this in her filing?
This is in the orders. There was a motion that she filed to be allowed to get records from that laboratory because the lab wanted the trial court to give them an order in order to release their testing records to her.
This was testing done before the second
This is
trial?
testing done before the second trial.
And the court granted that
The
order.
court granted that order the very same day, and after that, she asked not long after that for an extension of time in which to file her supplemental filing because she had an expert named Dr. Maher Noorhaddin who was going to work on the case. So she asked to give extra time for him, Dr. Noorhaddin, to be allowed to complete his work on the case. So the withdrawal in 2022 was not done out of a whim, out of any sort of ineffectiveness. It was done after the records would indicate, after reviewing what actually happened.
So these are inferences you draw from, time lapse, order she saw, things like that. And yet, her withdrawal, you could say, is kind of a wishy-washy withdrawal, right? Withdraw without prejudice, and then gives a reason as to why. It's like saying this might come back.
That was a reiteration of the withdrawal, and that was, I would say that was, Mr. Blackmon filed his pro se ex parte letter with the court, which was not served on the government, which is why it's ex parte, on August 19th, 2023. She had just filed her reply at that point, so actually would not have had that letter, but I'm sorry.
Would not
Have had that letter, but she would have, I believe, if the court's indulgence. And I don't want to get into extra record information, but she obviously had been speaking to Mr. Blackmon.
But
So she had already, all she was doing in the second letter was reiterating the withdrawal of retesting on items 7 through 10 that she had made the year prior.
Is it that she made, from your point of view, she made a strategic decision, but Mr. Blackmon didn't like it, so she
He
was
didn't
trying to
like it.
keep the option?
Right, she's just holding a placeholder. There was some indication, I don't recall the date, Your Honor, but that she had mentioned in her reply that he was seeking to file pleadings in regard to those items. And I can't remember off the top of my head whether or not that was in her motion to withdraw from the case in September, or whether or not it was actually in her reply brief. But certainly she had information that Mr. Blackmon didn't agree with her strategic decision. So at worst, she's saying without prejudice, because he feels differently than me.
Right, well, that's an important thing, though, right? She is, after all, representing him, and
She
I mean,
is,
she's signifying that.
that he disagrees with her.
Right.
But given her investigation, there's no reason to think that his disagreement is based on anything substantive. I mean, I'm sure that attorneys and clients disagree all the time, but as defense counsel, you have to make strategic decisions on what's going to be helpful to your client. And if frankly, if PDS had retested these items, the swabs, which the record would indicate they did before the second trial, there's no reason to think that another bite at the apple is going to change anything, particularly when all you're getting is a pro se argument that I want the retesting because I think
So you're
DFS would
saying,
have done the case.
am I understanding you correctly that you're saying that even if the trial judge had in fact considered the letter from Mr. Blackmon, that the judge said, no, I can't look at it, the judge would have come to the same conclusion? Even the judge had thought, actually, Mr. Blackmon does not want to withdraw, has not authorized the withdrawal of the retesting of 7 through 9.
Mhm. I think that would be absolutely fine, Your Honor, because Ms. Block left that case in mid-September. He was appointed new counsel as of September 20th. And during that entire time after Ms. Reed was put on the case, she never moved to reassert the request for testing on items 7 through 10.
How long was it? How long was that period between Ms. Reed's appointment after Ms. Block went to PDS and the judge's order?
About 2.5 months. The Ms. Reed was appointed on September 20th, 2023, and the court ordered that she couldn't have another 180-day stay of the case on the 4th of December 23, and then decided the case on the 7th of December.
Was there another deadline in between there that was not, or is it just that she asked for 180
She just
days?
sua
if that was
sponte
denied?
asked for a 180-day stay.
Well, she said she was trying
Because
to get
she
that
was-
Innocence Project
Oh,
counsel
that's
and
right.
essentially pursue those retesting claims, right? And the court said, well, sorry, this has been 210 days already. By the time I give you that, it's going to be over a year since, I guess, 3 years at that point since he filed his pro se claim. And we got to move this at some point. And so you only get 30 days.
Oh, no, that was Ms. Block's request for an extra time. She asked for an extra 180 days to file her reply. The court ultimately said, I'll give you 30 days, and she filed her reply on August 9th, 2023. So this happened, all of this happened later. Ms. Reed was appointed on the 20th of September, and
I
then
thought this was where Ms. Reed asked it, and they basically gave her an end of December deadline, giving her the 30 days and denying her the 180 days.
no, it was actually Ms. Block that filed the reply. There were two requests for 180 days. Ms. Block asked in the summer of 23 for an extra 180 days to file her reply to her supplemental reply for the IPA motion. The court said, no, I'll give you 30 days. Ms. Block complied with that. Yeah, that was Ms. Block's request on July 3rd, 23. She said she'd been consulting with the Innocence Project about how to proceed for a pro se request for testing, and we're requesting a 180-day extension. On the 10th of July, the trial court said, I'll give you 30 days to file your reply. I've already granted you 210 days of extensions just on the supplemental reply. And mind you, she had already been granted 210 days before she filed her initial supplemental IPA motion. And the court frankly warned at that time that after you file your reply, I'm going to decide this case on the items that are on the docket. So that was noticed as of the 10th of July that the court was going to decide this case. By the 9th of August, then Ms. Block had completed the filings because she filed her reply. Ms. Reed was appointed September 20th and then asked for a 180-day stay, not to do anything, just to stay it because the Innocence Project thought they would assign an attorney shortly after the holiday season. And she did not say it's because Innocence Project wants to do retesting, anything like that. It was much vaguer. It just said that she wanted the case halted because, quote, conflicting actions could be taken in this case that may be contrary to how the Innocence Project intends to proceed after their investigation. And the Innocence Project needs to make its own assessment of a best course going forward in Mr. Blackmon's interests.
So, I mean,
That's-
is it your view, though, that Ms. Block and Ms. Reed overrode their client's wishes because they felt that they could not ethically seek retesting of items 7 through 10? In other words, could not make a non-frivolous argument for retesting of items 7 through 10?
I mean, everything on the record would indicate that's the case. There's no filings by Ms. Block other than the request for a stay. So I couldn't go as far as to say that we know her thoughts, but you can tell from Ms. Block's actions in an own investigation that went as far as to hire the expert, that there's certainly valid reason to infer that she had legitimate reason to not seek that retesting.
You
But-
wouldn't expect.
I'm sorry, but one could also infer that maybe she thought that the Innocence Project attorney might have, who are more specialized, I take it, in this kind of business, might be able to come up with different arguments and present them in good faith.
I mean, perhaps, but I mean, there's nothing that specific on the record. It's
Well-
not clear. I mean, all that you have when you have an attorney, Ms. Reed, who came on the case as of September, who had been given Mr. Blackmon's letter, who would have known that he, even by reading Ms. Block's filings, that he wanted to file additional pleadings. She didn't do that. So just to say, maybe
Counsel, it's
someday
fair to
Innocence
say
Project.
that you would almost always have to infer that, right? Because an attorney would be damaging their client if they went on the record and said, I don't have any non-frivolous grounds to make these claims.
I mean, we don't have an Anders
We don't have
equivalent,
an Anders,
right?
right, not that
At this stage.
Not that I'm aware of, no. No, but I mean, just to say that the trial court abuses discretion when ultimately, as Your Honor, Judge Howard had said, was so what? The only thing that was really pending in front of the trial court at that point was a request for testing of items 1 through 6. As the court recognizes, that is not going to do anything beyond, at very best, exclude him from putting any DNA on her clothing or on the comforter. And that's not anything close to getting you a reason to have undermined confidence in the trial outcome under 4133D. And the other thing too that Ms. Block investigated as well was why wasn't there testing done on items 1 through 6 in the first place? And obviously she came up with the answer being there's nothing in the trial files to indicate, and the trial counsel doesn't know. But again, that's not enough to say that that was ineffective assistance of counsel, whether you look at it as an independent claim against the trial attorney, or if you look at it under the requirement to show that testing wasn't done and the reason was something that would be recognized under 23-110. If you look at it under the IPA statute.
To what extent did the withdrawal of claims 7 through 9 have an impact on the trial judge's decision to deny the testing of items 1 through 6?
The court simply recognized the same thing that Judge Howard recognized here today. It just doesn't make a difference. If items
No,
1 through
had
6.
the claim for retesting of 7 through 9 still been part of the request?
What difference would it make in regard to items 1 through 6, Your Honor?
How would the trial judge's order have been different?
I don't know at that point, because then you have to get into the fact that the pleadings before the trial court at that point are defense or Mr. Blackmon in his pro se motion specifying 3 types of testing that he would have wanted to have done. And the government's very cogent response that that's a red herring. One is we've already done short tandem repeat testing. And there's no reason to think that if you tested a few more alleles now under the testing that goes on today, that's going to change the alleles that were found to be his. The other ones were a testing method that's used in mixtures, as the court pointed out. Again, as the court pointed out this morning, there wasn't a mixture here. We're not talking about multiple male DNA in this. It's the victims and Mr. Blackmon's DNA that are found. And the third, I believe, was a type of testing that's done in the UK. So we're still not dealing with, when you look at the papers that were filed after the investigation that was done, that you have any reason to think that the court, based on what had been filed, it was going to be different, even if you had the 7 through 9 requests.
So counsel, a lot of that is us filling in the blanks. If we decided, okay, well, trial court didn't do its homework here and it missed this, you know, A, what harm is there in sending it back for them to look at it? And B, to the extent we went that route, do you think it could be fairly limited to just the retesting portion?
For items 7 through 9? I think it could, because when you look at what was in front of the court at the time, there was still no evidence of anything that would get to the level of items 1 through 6 not being tested due to 23-110 concerns, like ineffectiveness of the second trial counsel. And I mean, that's a possibility, but again, based on the fact that the court made this decision after that case had been pending for 2.5 years on its docket, after having 2 attorneys been assigned to Mr. Blackmon, and at no point has anybody claimed in these appellate proceedings that Ms. Reed was ineffective for not resuscitating the retesting requests on items 7 through 9 or 10, and no argument that the court abused its discretion by not granting that extra 180 days. We just don't have any reason to undermine and reverse the trial court's decision in this case.
Now, the trial judge decided not to read Mr. Blackmon's letter to the court.
Correct.
Based on this notion that, well, there's attorney-client privileged material in there and I shouldn't be reading, right?
Correct.
Not necessarily correct, right? Because he's providing it for a specific purpose. So probably he's waived his privilege claim. And really your argument is this is ex parte.
Right. He did not.
Ex parte communication. Judge Shanker has brought up that he asked that it be put on the docket, which frankly I had missed. How does that affect the ex parte, whether this really is ex parte? But more to the point, given that the judge herself wasn't really thinking of this as an ex parte communication, and that might be the reason why she shouldn't be looking at it. Whether there just really wasn't a sufficient inquiry. The judicial mind was not focused on what was in front of the judge and whether in fact it was an ex parte communication, because she just wasn't thinking along those lines. For example, what did it mean that he asked that it be put in the docket? The fact that he's pro se, does that mean that he should have been told, you know, the court cannot consider this unless the other side looks at it?
Right. First of all, it was an ex parte filing because the government was not served with it. Second, even if, and I don't recall the specific wording of the cover letter, except that he was saying that I want this filed under seal. So you could ask for something to be docketed. It's still not going to be available to the government or to the public if it's filed under seal. So again, that would not make it any less ex parte.
But the cover letter did also say that he didn't want his claims waived. It was very vague, but
It was very vague.
It was a broad statement of, I don't want claims waived, and someone's waiving my claims, and it seems like that could have easily been shared with opposing counsel, shared with the government.
The court did not do that, Your Honor, but it just said it wanted the letter filed under seal to preserve any arguments appointed counsel Block may have waived. And I don't think that frankly, the trial court did anything erroneous by not looking at that letter. I mean, if you have an attorney assigned to somebody who now is acting pro se, very often the court will say, we're not going to accept this. You have your attorney speak through your
But
attorney.
that's not what the judge, that wasn't the reason the judge gave. And what Judge Howard is saying, there was a letter, there's a cover letter that says, I don't want to waive my claims. And then there's an attachment to the letter, right? I guess an email or some exchange, some correspondence.
There's a letter from Mr.
Right.
Blackmon to his attorney in there. So clearly chock full of attorney-client
Right,
privilege
but
materials.
that's different from the cover letter.
The cover letter was to the court clerk and it just said, please file this under seal. And
And it didn't
It's-
say why,
it said to preserve any arguments appointed counsel Block may have waived.
right?
My understanding is from Judge Anderson's responsive letter was that she did not look at that cover letter either. And
Well-
I'm having difficulty finding that right now in my record, Your Honor, I apologize.
Because it was addressed to the clerk.
It was addressed to the court clerk. Indulgence for.
Well, it's pretty clear that the
Yeah,
judge
why is that enough?
looked at that. I mean, knew something had been filed. Looked at that. Oh, I got that.
I was trying to find Judge Anderson's letter, Your Honor. I wasn't. Oh, here it is. It says the court's clerk actually did docket the information under seal on August 30th. And that it wasn't read and it remains under seal and will not be considered by Judge Anderson at any point. And that it was, the court was forwarding that information to Ms. Reed. And the copies also indicate that it went to Ms. Block. Just the court's order. But so again, we're still in a position where Ms. Reed was on that case for months afterwards and did not make any request to
For 2 months.
Resuscitate.
That way you said 2 months.
2.5 months.
2.5 months.
Didn't make a request to resuscitate his testing of items 7 through 9. And based on that fact, there's this, particularly since no one here has claimed that Ms. Reed provided ineffective assistance or that the court abuses discretion by declining her stay request.
How would that claim, I mean, we talked a bit about this before. How would a claim of ineffective assistance by IPA counsel be brought? How would you?
And I mean, to
develop that
follow up
record?
on that question, you take the argument on its premise that there is such a claim in your brief, and I mean, you never say assuming. So is the government conceding that there is, I didn't mean to cut off answer to Judge Ruiz's question, but it's part of the same question. Is the government conceding that there is an ineffective assistance claim against IPA counsel?
No, absolutely not.
Seemed
we're
like
not doing-
seemed like you did in your brief, but
Against Ms. Reed or
no, not
or
in this
Mr. Black?
particular case, but that there is such a thing.
that you can?
Structurally.
And then Judge Reese's question is, how would it be brought?
I mean, I just don't know, and I have not thought about how it could be brought. I don't know if it fits under 23-110. And I'm sorry, I don't know the answer to that question, Your Honor.
As I started to bring up some of the confusion on that, and Judge Schenker cut the questioning with pointing out the statute, you would agree that at least that, based on the statute, bringing that as a theory that this could be brought, there's the opportunity to make an argument as part of this IPA kind of claim, right?
There's an opportunity as part of the IPA framework in the statute to say that testing was not done because your prior counsel did not have testing done. And it would, the evidence was not tested for reasons that would entitle the defendant to 23-110 relief. That's under 4133 A3C.
Would you concede then that that goes only to substance, and some of the procedural concern I was raising before may not matter to that?
I think that would be just a substantive question about why your prior counsel, like meaning trial counsel in this case, had not done something that he should have done. But I don't think that answers the question of would that allow one to bring a 23-110 claim against an attorney who's been appointed to represent the defendant in an IPA claim. That really seems to go more to the merits of making the IP claim in the first place. And as we've pointed out, the request to test items 1 through 6 wouldn't meet the Strickland standard under 23-110, which is essentially the same as the materiality standard under 4133D, whether or not you've brought a proper IPA claim in the first place. And I would say there was just a brief discussion in earlier argument about Mr. Blackmon's additional claim that somehow the fact that the victim was required to shower before or after the incident and before the swabs were taken would somehow corrupt the DNA, so that those original results and the retesting results of the swabs would have been somehow affected. The DNA was found in the victim's mouth and vagina and anus. This is not a situation where, and I think you could almost take as a matter of common sense that if one takes a shower and DNA is washed off or broken in some manner, that doesn't turn one man's DNA into another man's DNA. And that's essentially what pro se defendant would be asking the court to believe if you get down that road. And there's no reason to think that that's a viable argument in any way, shape, or form. And for all these reasons, we would respectfully request, unless the court has further questions, that you affirm the judgment of the district court. Thank you.
A few points based upon what the government said. They started out talking about how Ms. Block asked for certain things so she can investigate certain things. There is no evidence in the record whatsoever that she followed up on anything that she actually asked to do. There's no voucher for this expert that she was supposedly, I mean, she's CJA, you got to get vouchers for that stuff. There's nothing in the files. I supposedly got all the files. There's nothing in the files that shows she consulted with anyone or that she actually did the things. And in fact, on the docket even, she made a request for the court to appoint her to be able to do a compassionate release motion. That never happened either. So you can't assume that there was follow-up on things just because counsel asked the court to appoint or asked for investigatory ability that it was actually done. I mean, at least not without proof that it was done. And you can't assume in this case that it was. And, I want to say there's nothing strategic about torpedoing the man's case.
Let
And
me
we don't.
Pause you for just a second there. You were saying that none of that can be assumed, but that would be assuming that a standard like Strickland does not apply, correct?
That would be assuming what?
That a standard like Strickland, which has a presumption of competent representation, does not apply, correct?
Well, I mean, are you asking me, can we assume that because counsel says, give me permission to do something, that they did it?
You were saying there's absolutely no evidence on the record that this investigation was followed up on, that any of the leads were, et cetera. And if we were looking at this under the Strickland standard, it would be the appellant's burden, it would be Mr. Blackman's burden to prove that that didn't happen, as opposed to the counsel themselves doing.
Right, and I'm not making that part of an ineffectiveness argument. Really, I'm just responding to what the government said was, hey, she was good, she did all these things, but all these things were requests and not necessarily follow through. That's my point. The other very important point to make is that we don't know, the government says, hey, here's this active guy doing all this pro se stuff. He's really on it. And he's pretty cogent. I mean, his letter to the court was very cogent about how counsel was torpedoing his case. We don't know that he received the court letter at the BOP saying, I'm not going to consider what you did, because dollars to donuts, had he gotten that, he would have done something about it. I've sent many letters to the BOP that never reach my client. You can never assume that a letter to the BOP is going to reach him. So that really can't be held against him that, well, hey, he didn't do anything after he got this letter, because everything in the record would say that he would have. And another important point to make against what the government says, the government's theory is that, well, the attorneys must have disagreed with him. They must have thought these things were frivolous. But that's not really what the record points to. What they keep saying is, we need specialized counsel. We're not good enough to do what he needs. That's really what the record says. Let's withdraw it. He needs specialized counsel. What does that mean? It means I'm not adequate. If I came in here today and I said, I'm not going to do that, we need specialized counsel. What am I saying? Then I'm saying I'm not adequate. I'm not equipped to do this. I need someone more specialized. So I think it would be very fair to assume that it's because they thought it was frivolous, or what have you.
But I mean, at the end of the day, Ms. Daniels, Mr. Blackman did not have the representation of the Innocence Project at that point, right? So we've got a counseled defendant who files the defendant himself files something pro se and says, I want X. And we've got the counsel filing something saying, we don't want X. And we can theorize about what the Innocence Project might have wanted, but that's not before us. Wasn't before the trial court. So what's the trial court supposed to do in that situation? I mean, in the normal course, the trial court says you're counseled. You've got to take your counsel's word. And I assume that your counsel's word is based on their educated and reasoned judgment as an attorney. What takes us away?
They don't say, figure out if it's frivolous or not. If this guy wants compassionate release motion, hey, figure out if it's frivolous or not. They say, file a supplement. And, what she did was not a very ardent supplement. It certainly didn't speak to why his request for certain DNA testing would make a difference, that they're new, that it actually, would be better. Yeah, the government responded and said, hey, it doesn't matter because, yeah, there are new tests out there and it actually goes to more alleles, but we don't have to do that because let's presume that the same alleles would come up. And that's a presumption. So really what it is
I
that
mean,
the
it's a
government down
presumption
below
that-
agreed.
Wouldn't it be a presumption that different alleles would show up as opposed to additional alleles?
No, I'm saying that the government in its pleadings did talk about the different tests he requested. And I'm recalling that one of them, they said, yeah, it has actually advanced, and it has advanced in the way that instead of just detecting X amount of alleles, it's even more now. But we don't have to go there because the government was presuming that, the same alleles would come up. And, I'm
My
saying that,
question was, why would you presume anything different? Like, wouldn't there need to be a basis for that?
well, I don't know. I'm not a DNA expert and, and it wasn't passed upon by the court. I mean, I see that the court is suggesting that perhaps it wants to actually rule on whether retesting would have been beneficial or not. But, the order appealed from doesn't even speak to it. So
I wouldn't assume anything about our questions about which way we're going to rule as a general matter.
okay, I
And
know
I'm more
that.
so reacting to the way the burden seems to shift around.
I know that. I also want to mention that what the court could have done with the letter, if there was any question about, hey, what's going on here? Is it because counsel thinks something's frivolous? The court could have held a status hearing and said, hey, I got this letter. He's saying, he doesn't want to waive it. I have to rule. And if the court didn't want to wait on, another 6 months for the Innocence Project, then in all fairness, then rule on the pro se, ask the attorneys, you supplement then, but they're saying, oh, well, we're not specialized enough, we're not adequate to do it. We're going to wait for the Innocence Project. So I don't think either Attorney Block or Ms. Reed, and I happen to know Ms. Reed, that, they just kept shoving it off to the Innocence Project. We don't want to do anything. We're not good enough, basically, is what it says here. I mean, why didn't they file a real supplement? And that's what he says in his letter to the court, and his letter to counsel. You were hired by the court to file a supplement for me. You haven't done that. You've taken away instead of added to. No fair. I want a decision that looks at both, because otherwise it's going to wind up exactly the way it wound up. I mean, he was right about what would actually happen and how he would be prejudiced, and the court did intertwine it. It's not like the court only dealt with 1 through 6 without being influenced by the withdrawal of 7 through 9. So again, I would ask the court to vacate the order, give him another bite at the apple with a supplemental pleading or not. And again, if the court is not going to do that and is going to affirm the order, then be very clear that he has the right to go ahead and bring this and not be barred by it being some successive pleading, or that he somehow withdrew it for good and he would get denied on that basis. I thank the court for its time.
On the 7 to 9,
See you.
on the 7 to 9.
Right, yeah.
I mean, there's no bar to successive IPA petitions, so it would only be a matter of the court saying it was collateral estoppel or something like that, right? So,
Yeah, I mean, again, Judge Anderson's title to her order is she is denying his pro se motion, not in part, in full. I mean, there's nothing that says in part there. I read it as she is denying it in full. He withdrew it. He's, you know, I mean, she doesn't even say in the footnote withdrawn without prejudice. He withdrew it, and I'm denying his pro se order. I'm denying the supplement. So if I was a judge looking at that new, let's say, you know, because he goes ahead and says, hey, that wasn't decided for me. I have a feeling that I'm going to wind up on another appeal with, you know, a superior, I mean, I wouldn't be representing him in Superior Court. I don't do trial work. But, you know, a Superior Court judge saying, hey, I can knock this out in an instant and say, you already had your bite at the apple. You didn't take it. And that order, that previous order denied your entire pro se motion. There was nothing about in part here. No, thank you for your time.
Thank you to all counsel. The case is submitted.